Be ready in 3, 2, 1, start. The directions which have been issued by the learned single judge in paragraphs 15, 16 and 17 of the impugned judgment and order have not arisen from the suit or proceedings in which the original decree was passed, nor do those directions have any reasonable or proximate relationship with the lies between the plaintiffs and the defendants. Ex facie, the directions in paragraphs 15, 16 and 17 of the impugned judgment and order relate to matters not arising out of the suit. In the circumstances, those directions cannot be construed as directions in a judgment passed in the exercise of the appellate jurisdiction in respect of a decree or order made by a court subject to the superintendence of the High Court. The special appeal is hence maintainable. On the merits of the special appeal, we find considerable substance in the submission which has been urged on behalf of the appellants. The second appeal filed by the Basic Shiksha Adhikari was dismissed by the learned single judge on the ground that it was not maintainable since the officer was not competent to file an appeal against the judgment rendered in the first appeal by the additional district judge Etawah in the absence of a sanction of approval of the state. If the appeal was not maintainable, it ought to have been dismissed as such and the matter would rest there. However, the learned single judge has transgressed the jurisdiction of the court in a second appeal by issuing directions of the nature which are contained in paragraphs 15, 16 and 17 of the impugned judgment and order. Those directions had absolutely no nexus to the lies between the plaintiffs and the defendants and are akin to the exercise of the jurisdiction under Article 226 of the Constitution by the learned single judge. While exercising the jurisdiction in the second appeal, the court has to denude as to whether a substantial question of law arises for the consideration by the court. Holding that the second appeal was not maintainable, the learned single judge was not justified in issuing the directions as contained in paragraphs 15, 16 and 17 of the impugned judgment and order which we have extracted in the present judgment. In the circumstances, we are inclined to allow the special appeal. However, we expressly clarify that nothing contained in this order shall amount to any expression of opinion by the court on the merits of the decree or order of the first appellate court which has ensued to the benefit of the plaintiffs, and the plaintiffs would be at liberty to pursue their remedy to execute the same according to law. The special appeal filed by the appellants is allowed by setting aside the directions of the learned single judge contained in paragraphs 15, 16 and 17 of the impugned judgment and order dated 28 May 2013. The special appeal is accordingly disposed of. There shall be no order as to cost stop.